Do you think this man here is drunk or tired?
Like, why you do that, man?
You gotta listen.
Relax.
Do what she says.
I do that, but I don't have nothing. Like, why you are doing that?
Well, his $27 million lawsuit against the town of Lloyd claims he was merely tired. The body cam footage available to us says he was driving under the influence. But do either of those possibilities excuse this?
I'm not.
Well, that's a pro se opinion for you to tell me down in the comments below. I'm America's attorney. I've been a lawyer for over 24 years. I've helped over 1.5 million people. Let's break down this lawsuit filed by Muhammad Nashat Khalid and the arrest that led up to it. On December 11th, 2024, Muhammad pulled his car over on Route 9W in the town of Lloyd because he was exhausted and needed to rest. I'm not sure about that, but who cares? According to the complaint, a 911 call brought New York State troopers to the scene and officers from the town of Lloyd Police Department, though they also arrived. After what the lawsuit describes as a short exchange, officers decided to arrest Khalid. Online articles report, however, that Khalid was put through field sobriety tests that he did not pass. One way or another, Khalid ended up in handcuffs, which is where we see, thanks to the body camera footage, this interaction.
You push back at me again, I will throw you on the ground.
This is your right, you know?
Relax.
But you know what?
Relax.
Stop.
No, I'm not.
Khalid claims through his lawsuit that he was confused by the instructions to spread his feet and was trying to ask questions when Officer Funchess slammed him to the ground. Khalid immediately lost consciousness. Okay, that's an understatement. He was handcuffed behind his back and he landed basically headfirst on the pavement. He was out cold. And if you don't believe me, well, listen closely to this clip here.
Funchess put him to the ground. He's out cold.
The filing claims he was taken to Vassar Brothers Hospital where he remained unconscious for several days before waking up. The lawsuit describes serious and lasting injuries from that night, including a fractured elbow and fingers, damage to his knees and shoulders, head trauma, memory loss, disorientation, and a permanent loss of the use of his arms. Beyond the physical harm, Khalid says the assault left him humiliated and traumatized, cost him his job, and left him unable to work. Which, of course, leads us to this. This lawsuit, filed August 26, 2025, in the Northern District of New York, names Officer Eric Funchess and the town of Lloyd as defendants. Against Funchess, Khalid alleges violations of his constitutional rights under 42 U.S.C. Section 1983, specifically excessive force in violation of the Fourth Amendment. Yeah, I mean, we saw that a little bit. He also brings state law claims of assault and battery, pointing to the physical violence he says was inflicted while he was handcuffed and compliant. Yeah, we actually saw that a little bit too. Finally, Khalid brings a respondeat superior claim against the town of Lloyd, stressing that Funchess is an employee of the town and committed the alleged assault and battery within the scope of his employment. Okay, I'm not sure why I'm saying alleged. I mean, it's right there in the video. He definitely battered him. Through these claims, Khalid seeks substantial damages. $20 million on the federal excessive force claim, another $5 million on the assault and battery claim, and $2 million on the respondeat superior claim, arguing that his injuries, both physical and emotional, were the direct result of unlawful police conduct. The legal standards in Khalid's lawsuit focus primarily on 42 U.S.C. Section 1983 and its protection against excessive force. Federal courts applied the objective reasonableness test, which was established in Graham versus Connor in 1989, which asks whether the level of force used by an officer was justified under the circumstances. The complaint stresses that Khalid was already in handcuffs behind his back, compliant for the most part, unarmed, and surrounded by multiple officers when Officer Funchess allegedly lifted him and slammed him to the ground. Again, I cannot believe I'm still saying allegedly. It's like this reflexive thing that lawyers do. I mean, you can see him do it right there in the body cam footage. Those facts cut strongly against any claim of reasonableness, since the use of force must be tied to a threat or to some resistance that did not exist. In addition to the constitutional standard, New York common law defines assault and battery as unprivileged physical contact intended to cause harm or apprehension. By alleging that Funchess acted violently and without justification, the complaint postulates the same incident as both a constitutional violation and a state tort. Finally, through the doctrine of respondeat superior, the town of Lloyd may be held liable if a court finds Funchess acted within the scope of his employment. Together, these legal standards frame the central issue of the case, whether a police officer's decision to use force on a restrained and non-threatening individual was just not unnecessary, but also unlawful. Although Khalid's complaint does not include a formal Monell claim, it still places his encounter in a wider context by naming both Officer Funchess and the town of Lloyd as defendants. I feel like my editor at this point is trying to have a competition, see how many times I'm going to say respondeat superior and how many times I'm going to say Funchess. Funchess, Funchess, respondeat superior, Funchess, respondeat superior, Funchess, Funchess, respondeat superior. By invoking respondeat superior, there we go. The suit highlights that municipalities can be financially responsible when their officers commit misconduct while on duty, even if the officer's actions are unlawful. This framing inevitably raises questions about the department's training, supervision, and use of force culture. In the Hudson Valley in New York, other civil rights lawsuits in recent years have drawn attention to aggressive policing practices in small towns where limited oversight can sometimes allow excessive force to go unchecked. Khalid's case fits within that broader conversation, a claim that what happened on Route 9W was not just an isolated misjudgment, but a symptom of how vulnerable individuals can be when police authority is exercised without restraint. And by linking his serious injuries, his job loss, and his permanent impairment to the actions of a uniformed officer, the lawsuit suggests the problem reaches beyond just that one officer to the systems that allowed it. Parenthetically, I'd like to add that neither Officer Funchess or any of the other officers who were there when the assault happened really seemed alarmed by what he had done to Khalid.
Get him up, get him up.
Nope.
All right, EMS.
Yep.
Call EMS.
325 County, we have EMS dispatch your location.
325 requesting EMS your location. Just confirm you said you're in front of the Ulster Inn.
That's affirmative.
Just put him on his left side. Yep. Put him on his left side.
325, you in nature for the request.
I don't want to say callously indifferent, but if that's what you're saying, I'm listening. Now, the town of Lloyd and Officer Funchess are expected to file responses, likely including like a motion to dismiss or make other arguments that the officer is protected by qualified immunity. Qualified immunity shields officers from liability under Section 1983 unless two things are shown. First, that the officer violated a constitutional right, and that would be the Fourth Amendment. And second, that the right was clearly established at the time of the incident. That also would be the Fourth Amendment. In Khalid's case, the complaint alleges he was already handcuffed, compliant, unarmed, and surrounded by officers when Funchess lifted him into the air and slammed him to the ground. Federal courts in the Second Circuit, which covers New York, have consistently held that using significant force on a restrained, non-resisting individual violates clearly established law. For example, in the Sullivan case from 1999, the court stated that officers are not entitled to immunity if they use force against someone who's not resisting or posing a threat. Similarly, in Tracy versus Freshwater, 2010, the court emphasized that gratuitous force against a compliant arrestee is unconstitutional. Because Khalid's allegations fit squarely in that line of precedent, the probability of qualified immunity shielding Officer Funchess is relatively low if the facts are as Khalid describes. I mean, see for yourself one more time.
I'm not.
However, qualified immunity determinations are highly fact-intensive. If the defense can convince the court that Khalid was resisting, failing to comply, or creating a safety concern when the takedown occurred, a judge might find the officer's actions objectively reasonable under the circumstances. In practice, many courts resolve qualified immunity at the summary judgment stage after discovery when body camera footage and witness statements can clarify what actually happened. So while Khalid's allegations as pled make it unlikely that qualified immunity would bar his excessive force claim at the motion to dismiss stage, the outcome of the lawsuit may hinge on how much evidence supports his version of the events later on in the lawsuit. What are your thoughts on Khalid's lawsuit and the accompanying body camera footage? Do you believe he was a serious threat to any of the officers? Actually, you know what I'd really like to hear from you is how much you would give Khalid right now if you were on the jury and all you knew was what you learned from watching this video. Drop your pro se opinion down below in the comments and give me that number. And don't forget, while you're down there, to lawyer up with me, America's Attorney, by hitting that subscribe button. The channel is growing. I would love, love, love to hit 50,000 subscribers in the next few weeks. And if you want to be a part of the movement, it's really to subscribe.
Get in the car, kids.
Wow. Okay, sorry, that came out of nowhere. Hey, I'll be back soon with more legal breakdowns. You won't want to miss it. See you then.